Right, good morning, everybody again. I think online. Is it? Okay, technology I think is working. So um, uh, we have respondents witness, right?
Malik Al-Khatib from AMG.
Yes. Good morning, Mr. Malik.
Good morning, sir.
Hear me okay?
Yeah.
Okay. Would you like to introduce your witness?
Malik is from AMG, the technical services who take care of the furnishing and other repairing and works on site and in the factory.
Right. Well, would you like to introduce his evidence into?
Mr. Malik, do you have your witness statement in front of you? Mr. Malik?
Yes.
You have your witness statement with you?
Yeah.
April 3?
Yes.
Sorry, would you? Yes, I'm sorry. He needs to be sworn. Forgive me.
Sorry.
It's my fault entirely.
Mr. Malik, would you like to swear in or affirm today?
Sorry?
Would you like to swear in or affirm today? Do you have a holy book with you?
No. I don't understand.
Before you give your evidence, you have to swear. So would you be swearing in with a holy book, or do you just want to affirm? If you don't have your holy book with you and you're comfortable with affirming, we can affirm you in.
Mr. Malik, before you give evidence in court, you take an oath, okay? So there are two ways you can take an oath. If you don't have your holy book with you, you can do what's called affirm, which is a solemn statement but not sworn on a holy book. If you don't have a holy book, we'll do that, okay?
Okay.
Yeah. So the court associate's just going to take you through that now, right?
Okay. Okay, sir.
Okay, so for the
I have a small question. Will we can make it for translation in Arabic? Is better for me or what?
Affirm in Arabic, Shahla, yeah. You don't know. Do we have it in? Bear with me 1 second. Both Arabic, yeah.
Mr. Malik, pardon my question, but just to confirm, are you Muslim?
Yes.
Do you have a holy Quran with you?
Yes.
Okay, if you can just bring it with you so I can swear you in Arabic.
Okay. This Quran.
Perfect, thank you. Please place your right hand on it and repeat after me.
Okay.
أقسم بالله العظيم
أقسم بالله العظيم
أن أقول الحق
أن أقول الحق
ولا شيء غير الحق.
ولا شيء غير الحق.
We have the formality then. So, Mr. Mukharza, would you please introduce his witness statement into the
So,
record?
Mr. Malik, you are the CEO and owner of AMG Technical Services and Joinery Factory, who intervened in the project of OPSO Cafe. You appeared today as a witness in this case, and you have made a witness statement. Do you have your witness statement with you?
Yes.
So you confirm that you have prepared the witness statement and signed on
Yes.
April 18, 2023?
Yes.
Okay. And you confirm and affirm all the content of your witness statement?
Yes.
Thank you very much.
Morning, Mr. Khatib. Thank you for your time this morning. I
Welcome.
understand from your witness statement that your company had a contract with DIF Interiors, and pursuant to this contract, they engaged your company to fabricate joinery items requested from them for the OPSO Cafe project. Is this correct?
Yes.
And under this contract, payment was due from DIF Interiors. Correct.
Sorry?
Under the contract with DIF Interiors was responsible for the payment to you for those works. Is that correct?
Yes, right.
I have no further questions, Your Honor.
Okay, well, that was short and sweet. Do you have any re-examination, Mr. Mukharza?
Yes. Mr. Malik, in your witness statement, you said that you had Mr. Mark from...
That's not re-examination. You can only ask in re-examination anything that arises from cross-examination. Because when he doesn't challenge something in the witness statement, it's there, so there's no need to go back to it. He accepts it if he doesn't challenge it in cross-examination. It's only if something is challenged in cross-examination you're entitled to re-examine about it.
Done.
So you're done. So, Mr. Malik, thank you. That was very short and very helpful. You're obviously free to go now. Thank you.
Thank you so much, sir. Thank you so much.
So we have Mr. Sagaya next, I think.
Right, he will appear in person.
Sagaya in person.
Sir, I leave now?
Yes, you can leave now.
Thank you so much.
Your Honor, Mr. Sagaya is here as well.
Yes, well, I expected it. He's in person here? Yes, of course. Sorry, he's in person or online?
Person, no? Minutes, he's on his way.
Okay. I'll rise until he's here. Thank you. Is it Mr. Kutapan or Mr. Sagai? Which do you prefer?
Sagaya.
Sagai, okay. In which case, Mr. Sagai, you have to be sworn in before you give your evidence, so the associate will just administer the oath to you.
Good morning, everyone. My name is Sagai Raja Kuttapan. I'm director of Good Faith, founder and director of the Good Faith. Whatever I am saying here, it is true and just. I swear by Almighty of God. The evidence I saw it.
I shall give.
I shall give.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
Nothing but the truth.
Good. Mr. Mukasa, would you want to introduce the witness's evidence?
Yes. Mr. Sagaya, you are the founder and director of Good Faith, and you have worked on the project of OPSO Cafe, engaged by the defendant. Do you confirm that you have prepared the witness statements that you have in front of you?
Yeah, yes. This
And
is
do you
what I mean.
confirm that you signed and dated on April 24, 2023?
Yes.
And you affirm and ascertain the content of your statement?
Of course.
Thank you very much. Mr. Bull's going to have some questions for you.
Good morning, Mr. Sagaya. Thank you for your time this morning.
Good morning.
I understand from your witness statement that prior to this dispute with RAFID Gourmet, Good Faith Auditors, LLC, your company, had an existing relationship with the defendant. Is that correct?
Yes, we have been relationship with that our defendant. Okay, while executing this project, we have been contacted by their representative, and we signed the agreement to provide commercial and contract advice.
Okay. And prior to the engagement, you dealt with them before?
We have been in contact with them. Okay, even for a previous project, but some reason we couldn't able to conclude that one, and we didn't sign any agreement for that one.
So you'd never worked with them before this?
No.
Noted at paragraph 8 of your witness statement, and as you just mentioned, you were engaged by the defendant, and the specific date was actually on the 14th of January. Is that correct?
Yeah, that's correct. Because the first week of January we met and we discussed, and that 14th, the second week, they confirmed.
Okay, you stated paragraph 10 of your witness statement. Page 706 of the bundle.
Sorry?
Page 706 of the bundle. I'm not sure if you have your witness statement or the bundle copy there. It is page 2 of your...
Yeah,
the
page
version
number
you may
10,
have
yeah.
in front of you. Yeah. Stated paragraph 10 of your witness statement that the defendant requested various documents regarding the furniture, and then you state at paragraph 11 that the defendant could not get the documents from the furniture supplier due to the illness of the supplier's representative due to COVID-19. Do you agree that this is what you stated?
Yes, of course. Yeah.
Yeah, now refer you to page 634 of the bundle.
Sorry, which class? 16.
Yeah, so you might need to use a computer for this one. It's page 634. Now,
28th January, we sent that email to Natasha. That
correct, that's correct. So
Yes,
28th,
it begins on page 633.
it does, and then the relevant paragraph is, it continues on to 634, where the relevant paragraph here is that you state, however, we are communicating with the supplier to obtain the fire rating certificates and other confirmation on commercial grade. Though we have already paid 50% to the supplier, we are finding difficult to get such information from them. However, we shall continue to follow up and provide documents as soon as they are received. Makes no mention of the COVID-19 issue.
Yeah, here we didn't mention anything about the COVID-19 because what we replied, okay, as soon as that Natasha asked that document, okay, we informed the DIs to follow with the 360, who is the supplier, and they have been following with them. Okay, later on only we came to know, okay, that concerned person was leave due to that COVID sick. You can find some correspondence that email what she sent it. I'm not sure about which date. Okay, I can find it later on.
But was it not the case that the documents wouldn't be released until payment had been made for these goods?
Sorry, I didn't get you.
That the furniture supplier was withholding these certificates until you received payment?
I'm not sure about that one actually. Okay, what happened means, okay, it means DIPC paid that 50% of the payment to them. Okay, but they are not holding any document to release it actually. Okay, because the DIPC not able to contact that concerned person to get the document. That was the reason. Okay, later on, maybe after 15 days only, we came to know. Okay, that person was sick due to the COVID. That was the reason we couldn't be able to reach that person actually to get that related documents.
But could you just answer the question? So, is it right that you don't know whether they were withholding the documents, waiting for full payment? Is that what you're saying?
No, it's not like that, sir. Actually, okay. What?
So you have knowledge that they were willing to hand over the documents even though they'd not been paid in full. Is that what you're saying?
No, actually they have been paid that 50%. Okay, we couldn't able to get any sort of feedback from them. Okay, that was the reason. Okay, we couldn't get that related documents. Okay, it's not related to any other issues. Later on only we came to know this is due to the COVID, and later on they issued that documents.
So they were willing to issue the documents even though they'd only been paid 50%. Is that what you're saying?
Exactly. Yeah.
Okay.
Oh, sorry, Mr. Sagaya, did you ever attend the site?
Yes, of course. I have been visited one or couple of times the site.
Onto the site?
Sorry?
You went onto the site?
Yeah, exactly. Yeah.
What date was that?
It's. I'm not sure about the date exactly. It is after our appointment, 14th January, maybe that third week of January. That time.
Who did you speak to arrange that site attendance?
It is no, it's not only me. Okay, with that DIC colleagues, Isam is there. Okay, to come with me. Okay, he's the one shown that site.
So maybe the 30th. Is that what you said?
Sorry, sir?
Maybe the 30th of January.
Yeah, before 30th January. Third
before the 30th.
Yeah, before 30th January.
Okay.
Maybe third week of January actually.
And when you visited the site, did you inspect the works?
Yeah, of course. I want to brief how we came to the project actually. Okay, as I mentioned, first week of January, we met the defendant and they briefed what is the situation they are facing. Okay, they mentioned that there are lack of payment. Okay, we couldn't be able to progress the site and other works. Okay, so what is the solution? Whether we can go and terminate or how to continue the project and everything they asked. Then we went for that our proposal and we submitted the proposal and they agreed. And after
I'm sorry, you're speaking a bit fast for me.
Okay.
All I really wanted to know was, did you inspect the works when you visited the site?
Exactly.
And how long did you spend on the site inspecting the work?
If you see, maybe at site maybe 1 to 1.5 hours, and another visit at factory maybe 1 hour time. There are 3 visits we made. One
so
is
you went to the factory. Which factory?
It is factory at.
Who does it belong to? Was it furniture? Was it?
It is furniture. No, it is furniture. Not furniture. It is joinery factory.
So you went to the joinery factory, and how long did you spend there?
Maybe around 1 or 1.5 hours only. Then one day we visited that furniture, not furniture. Yeah, furniture. That loose furniture you can say. That 360 warehouse.
You went to 360. Yeah.
Yeah.
Okay.
At what time did you? So it's possibly on the 30th of January you inspected the site. Is that?
Not 30th January. It is third week of January. I can say 21st or 20th somewhat.
You don't have any records that you kept of that inspection?
I'm not sure whether I have any record on that. Okay, I will check it.
Right, and any of the photographs in this document, were they taken by you at that inspection?
No, it's not directly by me. Okay, it is taken by DFC, that representative. Okay, and they shared with me later on.
Oh, you took no photographs?
No, I didn't took it myself actually.
No photos or no records? Not even a knowledge, no photos, no records?
I didn't take it any photos on that particular day.
No knowledge of the date that you actually did this inspection?
I will check, maybe it is 20th or 21st around.
And what time was this inspection done?
As I mentioned, it was 3 site visit.
Just the inspection at the premises?
Yeah, inspection at premises, it's one day it is around 2:30.
Around 2:30 in the afternoon?
Yeah, 2:30 afternoon, 2:30 to 4 p.m. And another day it is around.
No, just the inspection of the OPSO cafe.
Cafe. It's around 10:30, 11 o'clock morning hours actually.
Right, and was the restaurant open?
No, restaurant is not open. It's just you can say site progress. So mess up with all the things.
So behind the cafe, there's a restaurant.
Okay, I didn't see that one actually. Yeah.
You couldn't tell if was the gate down in terms of the whole premises? Was the premises closed from the public or?
No, the premises is closed for the public. Only for the related site people can visit.
The premises has two operating businesses. It has the restaurant at the back and the cafe at the front.
I'm not sure about that one. Actually, I went for that only that site to see what is the progress going on. I never visited that outside the premises.
You couldn't tell if there's any staff around the front for the restaurant, the servers?
No, I didn't see anything like that in that site.
So who was it that asked you to come onto the site?
Site, actually, I have been requesting to visit the site to evaluate.
Who was the individual that escorted you onto the site?
No, actually, I discussed with Isam, that DIC representative Isam actually.
So Isam was there, or you just attended by yourself?
No, with Isam only.
Isam was there.
Yeah.
Now you've assessed the works that were on site, and you've assessed them at a value of 96,542 dirhams. Is that correct?
Give a minute.
Can we go to the document?
Sorry,
Yeah.
paragraph 26 of your witness statement, page 709 of the bundle.
Yeah, it is. If you see that evaluation for the work at site, okay, the defendant what they evaluated it is 96,000. Okay, due to some errors in that, when we evaluated it's 100,000. That is
So the defendant valued the works at 96,000.
Yeah.
And you assessed the works to be worth 100,000.
100,000 because due to some arithmetical error, that is.
Right.
Sorry, what's the difference?
It is actually that one of the item C in the
Floor finishes is the difference.
Yeah, exactly. Yeah, that 4,000. They mentioned that item, but they didn't. That computerized, they didn't add it actually.
Right. And you have no remarks in relation to any of these items, floor finishes. There's no remarks here, just the sum 4,240. What had been done in relation to floor finishes?
Floor finishes, if you see that it is a small quantity, it's not a complete laid thing. Okay, somewhere it is a mixed thing. Some tiles were laid and some
tiles were laid.
Yeah, something is not laid. Okay, it's
not laid.
Yeah.
Right. What was the condition of the site generally? Was it ready for the furniture or for the?
No, in my opinion, it's not ready to receive immediately. Okay, we need to have some kind of finishing to be done. Example, that the floor tiles, what I mentioned, it need to be fixed, and whatever that walls that works were progress. Okay, those things need to be done, and mainly that the painting. I don't think.
Sorry, just to take it slowly.
Yeah.
So you say that needed finishing. So the floors, walls, and painting. Is that right?
Yes, sir. Yeah. I don't think the painting is done. It's not completely. So before that, we cannot lay the furnitures.
Now, all of your figures, except for the floor finishes, agree, don't they, with the defendant's figures?
Yes, sir.
And how did you when you are on the site to calculate your figures?
So if you see, yeah.
What was your process? I want to know what the process was by which you reached your figures.
See that preliminaries we cannot evaluate by seeing the works. Okay, it is duration. Okay, the preliminaries there is an allowance for the 23,000 in the contract. Okay,
I know what the contract says. I want to know how did you measure the completion when you were on site?
Yes, sir. The preliminaries we consider only 50% what they claimed. Okay, it is based on the duration of the project. The project is not completed. It might be only progress.
I know. Please answer my question. What did you do physically on site to measure the degree of completion?
Degree of completion, if you see that we have to measure the quantity, how much that work done in terms of quantum of work. Okay, in that might be some of the things. If you, for example,
so you actually physically measured the work that had been done, did you?
No, sir. It's not a physically. It is lump sum contract. That's why we didn't go for a physical
so
measurement.
You did not. So you did not measure.
We didn't measure anything physically. Okay, but when we see that lump sum work, we can make it out. Okay, out of one room, how much it's completed, whether it is 50% or 70% or 100%. In that, because as a lump sum contract, we didn't go for a physical detail measurement.
Now, you say at paragraph 18 that you had not scrutinised the defendant's progress payment as it's not part of your service. So does that mean that the BO, that what they submitted, this document, progress payment, it's at page 740 of the bundle, page 740 of the bundle, you didn't look at this document, is that correct, when you did your assessment?
No, assessment time we did look at that document.
Yes.
What is that?
So what do you mean by I have not scrutinised the defendant's progress payment?
No, our scope of work while getting into the that agreement with them, it's not evaluating the progress, how to claim the payment. Okay, our scope of work, it is to contractually where they are. Okay.
I'm sorry, Mr. Bull, I'm a bit behind you.
Okay, so I'm referring to paragraph 18 on page 708.
Yes.
Thank you.
Yeah, and then also 742 where that document is, the progress payment.
Yes.
So what I'm trying to understand, and again, maybe if you just speak a little bit more slowly, you said you had not scrutinised the progress payment. Are you saying that you did not scrutinise this document that starts at 742? Is that what you're saying?
Yeah, that's correct. We didn't scrutinize the payment for making any payment application or evaluation because it's not our scope of work to scrutinize and to see it. Okay.
So when you went to do the evaluation, you went on site, are you saying that you didn't have this document with you to compare?
Yeah, of course.
You did?
Yes. We carry that payment application what they submitted to see okay, whether it is appropriate or not.
Right. Now, paragraph 29, you said the defendant has included the light fittings for which he had paid the advance payment to its suppliers in progress details. As the advance payment should not be considered for issuing the progress, I have excluded such items from my assessment.
Yes. If you see that the payment submission, they included that item for which they paid as an advance also. Okay. But if you see that the contract, it's allowed to include only that the site progress and that furniture, that material off site at site, or maybe the factory and anything, then that any other material available, not the advance payment, because they already received that advance payment 20% in advance, so they should not again consider that one.
Right. So just what you touched on there, you said that the contract was only relevant to the site progress.
It's not about the site progress. It is it's clearly mentioned in the one of the correspondence. It's site and factory and the material of the site. It's irrespective of whether it's at site or maybe off site. It's all the materials.
Right. So you're referring to an email, and sorry, I wasn't where you referred this email, so I don't have it immediately to hand.
I think that is email.
Sorry, can we just slow down so that I can follow?
Yeah.
Everybody's taking it a bit too fast at the moment.
Your Honour, I'm just searching for an email that's in the witness statement of Mark Takei.
Okay, well, you find that email while I
Yes.
catch up with you.
Yeah.
So, just on the light fittings, when you inspected the site, the light fittings were not yet on site, is that correct? Or don't you remember?
No, sir, I didn't see any light fittings installed on.
There were no light fittings installed? No, thank you.
Right, so the page is 251 of the bundle.
Sorry, sir?
251 of the bundle. Email starts at on 250, but this is the email that we talked about yesterday, where we had some proposed amendments to the payment terms. So this is what you referred to as the payment terms.
Exactly, yeah.
Exactly.
There is another email when they're confirming. Okay, I'll try to pick it in my document. A minute, under footnote, confirm that.
I'm sorry, I can't hear what you're saying.
Yeah, look, I think it's all right. I'll refer you to what we want to talk about. It's fine. I've seen the email that you've relied on the terms in that email that we've just looked at, correct? Exactly as you said.
Yeah, 770. Yeah. There is another email when they're confirming that payment terms. It is bundle 770, that page number.
770, let's have a look at that.
Yes, sir.
This email says, I'd like to confirm that there will be no more going back and forth and deviation from the original contract. Please see my comments in red below.
Yeah. That they revise the payment terms only for the item number 5, where they mention the work must be completed 100% to have the 5th payment.
But what Mark is saying here is that the original contract is what stands.
No, original contract with reference to that below email, that 27th October. That is the original.
So he states, I would like to confirm that there will be no more going back and forth and deviation from the original contract.
And my comments is below. It means they agree that other comments 1 to 4, and they didn't agree with that point number 5, 5th payment only. That is, okay, they are confirming, okay, the 5th payment, it is 10th, work must be completed 100%
Okay, so well, look,
Proceed.
you don't need to comment on what the thought process of Mark Takei was, but Mark
Fine.
has
This
given
is,
evidence.
with respect, I mean, this is irrelevant because this doesn't deal with the first progress payment. It deals with the terminal
Yeah.
payment, the fifth payment, and the 100% completion. So
The original
whether
contract.
whether or not this changed the original doesn't matter, because the first payment after the advance payment is what we're concerned with.
Correct, and my point is that the original contract was ultimately never changed.
Yes.
So in relation to the light fittings, you say that as the advance payment should not be considered for assessing the progress. I've excluded such items from my assessment.
Yes.
Correct?
Yes.
Why is that not the case for the furniture?
Give a minute. No, furniture, if you see that furniture, all the furniture is readily available and they paid advance payment and it's ready to put it in the site. Okay, it's available at the warehouse. Okay, anytime the site is ready to place it, they can come and place it. That's it.
But the furniture would not be delivered until payment in full, would it?
Sorry, sir, I didn't get.
The furniture supplier would not deliver the furniture until he was paid in full, would he?
It depends upon their contract, the DFC contract with the furniture contract, sir.
So you don't know whether the furniture supplier would deliver unless he was paid in full. Is that what you're saying?
No, actually, we didn't see any correspondence requesting that
So
payment
you
to
don't. So
deliver.
you didn't see any so you don't know whether he would deliver before he was paid in full or not, do you?
I'm not sure about that one. Okay.
No.
we are-
So I don't know if the furniture supplier.
It's your evidence
Deliver
that
before paying.
in relation to the furniture, you couldn't procure the certificates to certify the appropriateness of the furniture. That's your evidence here. You never ultimately ended up getting those certificates before the termination was.
Yeah, if you see that termination, it's happened end of
28 January.
28
So
January.
before the 28 January, you never got those certificates.
No.
You were asking, but they weren't released.
Yeah, we are asking and we didn't receive that certificate due to that illness of that representative.
And do you know the date of the invoice, 63? The invoice for the first payment? That
First
was
payment from
for
DA.
the first progress payment.
Yeah, it is up to claimed end of November 2020.
End of November.
Yeah.
So the progress payment claim that you had in your possession was done at the end of November.
Yes.
Right. And no change to that occurred from the end of November to the time you did your inspection in January.
Exactly, because
No,
there is,
okay, sorry. So not a single element of the works that the defendant had performed and claimed in its document of the 29th of November had changed at all when you assessed it a month later.
actually, I'm not sure about what was the progress they made until November because we are not in the picture. We couldn't able to evaluate what was that. Okay, when we are there, okay, whatever they claimed it is correct. And when we discussed with the DFC, they mentioned that we couldn't.
So are you saying that in fact, when you inspected, they could have done more work than in November?
Sorry, sir, I didn't.
Are you saying that as far as you're aware, when you inspected in the third week of January,
Yes.
they could have done more work since the end of November? That's what you're saying now? That's right, isn't it?
No, I'm not sure about what was the progress.
So you're not sure one way or the other whether they did any more work from the end of November?
From the end of November to
Till the
until
third week of January.
Third
So
week.
you don't know whether they did any more work?
Yes, of course. But what I received that information, okay, they didn't carry out any substantial work during that time actually.
Okay.
Your assessment on total is about 120,000 less than what the defendant had claimed. So in that document that that was dated 29th of November,
Yeah.
from your inspections, you found that they had overclaimed by at least 120,000 dirhams.
No, actually, I want to correct it here. Okay, if you see their payment, what they evaluated, it is 454,000. Okay.
Sorry, what document are you looking at?
Sorry, page 711 of the bundle, Your Honour.
Can I answer now?
Please.
Yeah. If you see that what the defendant claimed, it is 454,000 in the payment application. Okay. To claim that second payment, okay, they are not claiming whole payment. They are claiming, okay, that 20% second payment, it is 170,000, okay, to show that there is a progress they achieved more than 30%.
Right.
This breakdown, it is only showing, okay, what the progress achieved in terms of site or material. Okay. However, they included that advance also. That was the reason it's showing 53% progress. But when we evaluated, we removed all the advance payment what they consider. Okay, and we consider only the as per contract progress at site and that material at factory and wherever available. So it comes around 40% only. That was the reason.
You didn't. You removed the advance payment for the light fixtures and for the corridor feature wall.
Yes, sir.
You didn't remove all of it for the joinery works. Why not?
No, joinery works, it is available as a material at site. When we visited, we saw that material, it's available at site.
So joinery had been, some joinery had been delivered. Yes?
It's ready to deliver, sir.
Oh, so it wasn't at site. You said it was available at site. It wasn't available at site.
Sorry, sir?
You just said one thing and then another. The first thing you said was that it was available at site.
Not site, sir, at factory actually.
So you were wrong when you said it was available at site.
Yeah.
Yes. So some joinery was at the factory. And you've also included for the loose furniture which hadn't been delivered yet.
Yes, sir. It's not delivered at site, but it is as a material. It is available under the warehouse to deliver at any time.
Just try and repeat that a little bit more slowly because I'm missing a few words in there. So you're saying that the furniture is not on site, it's off site, it's in the third-party contractor's premises, locked up under their control. They own that material. EAF had paid for 50% of that material, but a little bit less than 50%, as we know, because the 15 lounge chairs weren't being held. Correct? You follow me on that point? They haven't provided the certificates as to the appropriateness of that material, and when they submitted this invoice and the progressive payment, nobody had inspected that material. Is that correct? Or if you don't know, you don't know.
Yeah. I'm not sure whether anybody inspected this material while submitting that.
Know.
I'm not sure about that one while submitting the payment application. But when we see it, that material is available at to place it at site. It is available at that warehouse. Okay. And
sorry, again, just back up a little bit more slow.
It is that material is available at warehouse to deliver to site.
The
factory warehouse.
Right.
Yeah.
Right.
To deliver at site at any time. Okay. So that was the reason behind it is included in our assessment also. If the site is ready, next day they can deliver it. That is the thing.
But how do we know?
You said a moment ago you did not know whether the furniture supplier would be willing to deliver until he was paid in full. You didn't know that.
Yes, sir. I didn't go through in detail about their contract. Okay, what is that payment terms? Okay, whether it is 50% payment or 100% payment to release that thing. Okay, as soon as approved and ready to go, they can deliver the material. That's what we assist.
But what do you know about the light fixtures? What is the difference between the light fixtures and the furniture? If the light fixtures are sitting in the light fixture supplier's store, you're saying that those two then should be payable. All that the defendant has done is rang his light fixture supplier and said, I need A, B, C, D, and E lights. And the response from his supplier is, the advance pay me X. And as the defendant has carried that out, he's calculated in his document that he's entitled to 100% payment for those, but you have contradicted your client there and said, no, that's not right. You can't just pay an advance payment and then expect to get credit for that on a contract of this nature. Is that right?
Yeah, I want to brief something. Okay, if you see that light fittings, okay, it is that material readily available at any time. Anybody can go and purchase it. Okay.
Go and take it, you mean?
They paid only that advance payment, and they didn't claim 100% because there might be some condition to deliver that complete material. In this case, that furniture, it's not readily available. They have to make based on the specification, something that fabrication and everything, they need to make it. Okay.
So the difference is because the furniture is custom as opposed to light fixtures that are...
Exactly. Yeah.
Right.
Yes, customized. Once they receive that advance payment, they customize that material, it's ready to deliver.
Where is this explained to the client in the contract that for custom materials, they are treated different to other materials that the defendant has just paid a deposit for? Is there a term in the contract for you to register, well, they're entitled to that, but not this?
If you see in general, okay, construction.
No, just in the contract.
What I'm saying, okay, if you see here, okay, contract doesn't say everything in writing, okay, it doesn't say anything, okay. At the same time,
in terms of the legal interpretation, my learned friend and I, we will make our submissions on that. But just in terms of the facts,
in terms
you saw no documents or agreements that specified that the furniture is treated differently to the light fixtures.
In terms of payment, I didn't see.
In terms of the contract.
No, that's why. In terms of the contract and related to payment terms, okay, it's not specified how to treat that one, okay. But generally, as an industry expert, okay, when we assess the material, is that only that material available, or it is already procured to make some custom? That is the difference, actually.
All right.
Yeah.
Good. I have no further questions.
Thank you very much. Mr. Mukazel, do you have any re-examination?
Mr. Sagaya,
Yeah.
I refer to your witness statement and the itemized worksheet you have provided. On the work executed at site, confirm that on the demolition item has been totally executed, 20,000 dirham.
Yeah.
So when you monitored this demolition on site, demolition work, and you said that you visited 2 or 3 times the site, does any of the OPSO Cafe representative present when you make your survey?
You are asking about only demolition or all the...
When you went to the cafe,
okay,
and to quantify the works done,
yeah,
and on the demolition item, you were with Isam and people from the owner from the cafe were present, right?
I'm not sure about the owner from cafe actually. Okay. Regarding the demolition, we couldn't see anything. Okay, because without doing the demolition, we cannot construct further. Okay.
Okay.
When we went, it is as I mentioned, 3rd week or around the end of January. Okay, it means we cannot see whether that demolition is there or not.
So
Okay,
everything was clean.
it's already clear, and they are progressing with that other finishing work to lay that further works actually.
So that's why you confirm that demolition
Yes,
has
it's
been done in total.
Yeah.
So
We didn't
there is
see
nothing
any.
to do on that side.
Exactly, we didn't see any debris to see of that demolition.
Okay, good. So my next question regarding the furniture, the 360 at least, the loose furniture. You said that they were ready to deliver.
Yes, of course. When we, as I mentioned, when we are following with that, getting the document, okay, they didn't, we didn't get any reply. Okay, after the termination, then we came to know that that concerned person is sick. That was the reason he couldn't able to deliver. Okay, in that correspondence also he didn't or she didn't mention anything about the payment and those things. Okay, so from that I can assure that they are ready to deliver, but unfortunately we couldn't able to get connection with that particular representative who is in position to deliver the documents actually. Okay, if the document is well and enough, then Clement might have agreed some amount for that one. Okay, that is the case.
Mr. Sagaya, where do I see evidence that they were ready to deliver? Where can I find that?
Actually, I can refer that when we are requesting that document.
Yes.
Okay.
So this is after termination. I need to know, in fact, I need to go back to the 30th of November. So where do I find evidence that I need to see that they were ready to deliver furniture on the 30th November? Because we're assessing the degree of completion at that date.
Maybe I'm not sure about documents, sir. Maybe we can find that evidence in contract between the DIFC and 360. Okay, it may give that clear-cut picture. What is the terms and agreement reached between them? If it's meet, then.
So you're not sure that they're ready to deliver on the 30th of November?
Yes, sir. I'm not sure.
Okay. Because you're talking about after termination.
Yeah.
Okay, please.
Okay. So technically speaking, if I revert your sheet, so you confirm that when you made your survey, 39% or at least 40% of the works has been achieved.
Yes.
And you reduce it based on the difference between your percentage and the one of DIF is mostly related to the factory off-site material, right?
Yes.
Because you disqualify the light fixtures and the corridor.
Yes.
So you reduce it around 95,000 dirham.
Not 95,000. It is around. January works we reduced. It's roughly yes.
From 149
149 to 53.
Right?
Exactly.
Okay, so this is the difference between you and the
Exactly.
DIF.
Yes.
So technically, your 40%. That's why you confirm in your assessment at paragraph 32 has overreached the 30% of the on-site works.
Yes. Not only site, including all the progress values.
So if the payment, my third question now, if the payment was released by the claimant according to the second payment obligation, do you confirm that the works will be ended up on December 30?
That's not something which arises out of cross-examination. And I don't think it's something he can answer anyway.
Yes, that's the work. I mean,
well, he wasn't cross-examined about whether or not they could achieve termination.
Let me formulate it in another way.
Formulate it another way.
If the furniture has been delivered on time, do you think that any dispute should arise between the parties?
No.
Okay.
Try again.
Again. You were involved in as a mediator too, as I saw in your.
Yeah, that's not going to fly either.
Not even.
No.
Did you try to mitigate between the parties? Because he said.
Yeah, that's correct. But we didn't get the opportunity to meet opposite
parties. This is not relevant.
Okay, so I just need to confirm from your side that 40% of the on-site work has been achieved.
Yeah, definitely. When we see that evaluation and what we see it, okay, as a expert where I work for the consultant, when we certify the payment, we see, okay, whether they reach the cutoff mark. Definitely, they reach the cutoff mark to pay the not 50%. It is that 20% of the what they claimed. It is 170. Yeah, 170,000 actually. That is the payment they requested. It's not about they're requesting 450,000. They requested 170, but they given the breakdown for the 450. Where there is something, it's a little bit wrong when they're considering that advance payment. That's it.
Thank you, Mr. Sagaya.
Thank you very much. Well, Mr. Sagaya, thank you very much. Your evidence has been very helpful to me, and you're free to go now. Thank you very much.
Thank you so much, sir. It's my pleasure.
Okay, gentlemen, you would like a break before you make your closing submissions. You allowed yourself an hour and 45 minutes in the original schedule. How long? So it's now just 11 o'clock.
Maybe if we go at 12, would that be okay?
That would be very good. Yes, if we could resume at 12, and then I'll give you an hour till lunchtime, and then after lunchtime, Mr. Mukherjee can have an hour too. How about that?
Sure. I won't need an hour, I believe. It's
Well, you can keep on going till the lunch break. We'll take the lunch break, and then we'll have an hour, and then after that, Mr. Mukherjee can address me. Okay, so I'll rise now until 12 o'clock, and then you can make your closing submissions. Thank you very much. Cool.
Thank you, Your Honour. Noted at the outset, this case hinges on the meaning of the words site works progress and the quantum of the works that were affected on site. The evidence of Mr. Fadali is that he understood site works progress to be one and the same as project progress. Section 51 of the DIFC contract law provides that in determining the common intention of the parties, the court can have regard to the nature and purpose of the contract, the meaning commonly given to terms and expressions in the trade concerned. Nature and purpose of this agreement is a construction fit-out works contract. The meaning commonly given to the terms site works progress may be common in the fit-out construction industry. It is the evidence of Mr. Fadali that he's experienced in this industry, and that's how he interpreted the contract. I refer the court, however, to section 49(2) of the DIFC contract law. This provides that if the common intention of the parties to the contract cannot be established, the contract shall be interpreted...
Sorry, article which? Article?
49(2). Contract shall be interpreted according to the meaning that reasonable persons of the same kind as the parties would give to it in the same circumstances. Your Honour, this contract was negotiated between a fit-out company and a chef who was also managing the operations of the restaurant and cafe business. The claimant was a retail purchaser of the defendant's trade. He was not experienced in the customs and traditions that Mr. Fadali now claims were baked into the language that he used. The claimant could not have anticipated that when Mr. Fadali wrote the term site works progress, Mr. Fadali in fact meant something completely different to this. Ultimately, however, there is no evidence whatsoever that this is a norm in the fit-out construction works industry. It is not established that the term site works progress is one and the same as project progress. Only the evidence of Mr. Fadali that this is how he interpreted the contract. Gaia acknowledged that he only took the view that the overall progress was relevant due to the fact that the contract was amended by way of an email dated 27 October, a matter that has been examined and quashed. As such, Mr. Sagaya did not share Mr. Fadali's interpretation of the original contract, and neither does the evidence of Natasha Abbas. Both Natasha Abbas and Mr. Sagaya noted that the act of paying An advance payment for goods or works is not regarded as progress towards a BOQ item. Mr. Segea suggested that for the custom goods, by industry practice, progress was awarded, provided that they were ready for delivery. That, however, was not the case here with regards to the furniture. There is no evidence that the furniture would be released. It's also the case that before the 30th of November 2021, the furniture had not been inspected by the claimant, had not been paid for in full, and the furniture supplier had not provided certificates as to certify that the goods were suitable and permitted to be used in the premises. Not to mention, the goods still had to be delivered, placed in the premises and cleaned, a critical stage for the use of such items in a food and beverage premises, particularly after they had been sitting in a warehouse in Dubai, a city notorious for fine dust making its way everywhere. Re-examination of Mr. Segea.
There's no evidence that property had passed.
I'm sorry, I don't follow the question.
Well, there's no evidence that the furniture manufacturer had passed property.
Absolutely, yes. No. In addition to the fact that there's no evidence that it had been paid in full. In fact, there's evidence to the contrary. There's no evidence that the furniture supplier had passed title to the defendant. Re-examination of Mr. Segea, my learned friend asked him about the progress percentage he recorded at page 711 of the bundle. He referred here to a figure of 40%. I believe he was referring to the figure 39.3% at the bottom of the table on page 711 of the bundle. My learned friend couched this question to Mr. Segea as site progress achieved, to which Mr. Segea responded, yes, the overall progress, very sensitively correcting my learned friend's question. Clearly indicated that you could not call progress of 39.3%, as noted in his paragraph 31 of his witness statement, as site progress. My learned friend spoke a little and then asked the same question again, to which Mr. Segea appeared to now understand the response my learned friend was looking for and answered yes. Your Honour, the first response was critical. It was clear that there is no technical trade secret that site progress actually means overall progress, as Mr. Fadali has suggested. On top of all of this, Your Honour, the reality is that the argument now put forward by the defendant just doesn't add up. The defendant genuinely believed that it achieved site works progress by ordering goods and paying the advance payment. It is unexplained why invoice 63 was not issued until the 30th of November 2021.
Sorry, say it again.
The defendant genuinely believed that it achieved site works progress by ordering goods and paying the advance payment for those goods. It is unexplained why invoice 63 was not issued until the 30th of November 2021.
I don't understand that. I don't understand the point you're making.
If the process, Mr. Fadali has stated that he has submitted in his progress payment claim that by making an advance payment and ordering goods, he was entitled to claim that as progress towards the works. Yeah. This is his belief. The fact, the evidence of Mr. Fadali is that by the third amount of the advance payment, thus he had ordered all of the furniture, had placed orders for a number of items which are listed in his witness statement in dot point, I believe in paragraph
your point that he'd actually achieved November?
Exactly. According to Mr. Fidali's witness statement, paragraph 26, pages 818 of the bundle, we would apply this logic now, touted by Mr. Fidali, the defendant would have effected 30% progress of the works before the 30th of October 2021, before it had even stepped onto the site. Yet Mr. Fidali never once conveyed this to the claimant. There is no evidence that he ever advised the claimant that pursuant to industry norms and along with the way that he interprets the term, he was now owed the first interim payment. Instead, it's Mr. Fidali's evidence that he had discussions with Mr. Almandel, and in those discussions, he relayed to Mr. Almandel, I would need his support to release the first advance payment straight after demolition of the existing cafe. Mr. Fidali's evidence here is contrary to his own purported interpretation of the words site works progress. His conduct here has reaffirmed the claimant's understanding of the literal words of the contract. Payments are made against the on-site progress of the works. It was clear from the defendant's own conduct and discussions after execution of the contract that payments were not triggered by off-site progress, and clearly not the task of ordering goods and making advance payments towards those items. Nor was it relevant that the defendant had exhausted the advance payment that had been made. Section 51 of the DIFC contract law also provides that in order to understand the common intention of the parties, the court shall have regard to all circumstances, including practices which the parties have established between themselves and the conduct of the parties subsequent to the conclusion of the contract. In this case, no practices were established for the payment against off-site progress. Again, it was the case that in his discussions, Mr. Fidali sought the claimant's support to release payment after completion of the demolition, a significant stage of the works. Also did not submit invoice 60 until the 30th of November. However, Mr. Fidali's conduct confirms that site works progress equals payment release. Secondly, the conduct subsequent to the conclusion of the contract, i.e., discussions about releasing the first payment by reference to a stage of the on-site works having been completed, again affirms the literal meaning of the terms in the document, meaning that the claimant says applies in this case. Opening submissions, my learned friend stated that the progress of the works was beyond 30% by 24 October 2021. Such statement later prompted the production of an email that was not part of the court bundle and was also irrelevant. If the defendant is of the view that ordering goods and paying advance payments is equivalent to site works progress, then this statement now perhaps makes sense. However, it must be noted that the email correspondence on and shortly after the 24th of October does not seek to say at any time that the 30% trigger has been reached and payments are now due. My learned friend also stated in his opening statement that payment terms were amended. No evidence of this was produced. In fact, Mr. Fidali confirmed his evidence as stated at paragraph 29 of his witness statement, as at the commencement of the works, the original payment terms applied. He further produced no evidence of anything to the contrary relating to the period after the works commenced. It must also be noted that the party responsible for the term site works progress being included in this agreement is the defendant. In fact, Mr. Fideli himself confirmed that he was the author of this term. Mr. Fideli has one interpretation of that term and the claimant has another. Section 54 of the DAFC contract law states that if contract terms supplied by one party are unclear, the interpretation against that party is preferred. Your Honour, the simple fact that I keep noting over and over again is that the contract says site works progress. It does not say overall progress or any other term that the defendant says was intended. Pursuant to Section 54, I submit to the court that the claimant's interpretation should be the preferred interpretation in this case. Now come to the matter of progress that was achieved. Noted in my opening submissions, progress of the works was assessed by 4 parties. Mark Takei affirmed his evidence that he was of the view that 10% of the works on site had been done, and added that the overall progress was, in his view, about 15 to 25%. Was not satisfied with the off-site fabrication of the joinery, noting that it was in an open yard and not according to specifications. Pasha Abbas confirmed that she attended the site and she stood by the assessment set out in her witness statement, say that if it was the case that the hoarding noted in the claim was referring to the hoarding erected by Macdas, then she agreed the defendant was entitled to additional 1,000 dirhams, 2.9% of the value of the contract, and nowhere near sufficient to materially amend the outcome of her recommendation. Also note that this concession is not new, and it is noted at paragraph 31B of her witness statement. That paragraph, she noted essentially that however she sliced it, however she treated both the demolition and the hoarding, the defendant was still far short of the required site progress. Further note that she also stood by the fact that according to industry practice, she did not recommend that the contractor be credited for 90% of the progress of the demolition works due to the defects in those works and the hazard it was causing to the operational restaurant. Mr. Sagaya inspected the works at the site. He could not recall the date he attended, nor did he have any photographs or notes from the attendants. He did, however, note that the site works progress, as at the date in the 3rd week of January, was of a value of 100,000 dirhams, 782. Progress calculated by way of value results in that being 11% of the works. Further noted that Mr. Sagaya attended the site without the knowledge of the claimant. As such, he could not have been made aware of the foul smell emanating from the restaurant's kitchen due to the plumbing defect caused by the defendant in the removal of the water feature. Sagaya did not seem to know that a restaurant was in fact connected to the premises. In addition to his assessment, Mr. Sagaya has given his opinions as to the sums the defendant was entitled to claim, as perhaps an expert witness might do. I submit to the court that such opinions in his evidence are not admissible and should. Mr. Fideli stood by his assessment that 50% of the overall works had been affected. This was notwithstanding the fact that he had read the matters set out in paragraph 29 of Mrs. Abbas's assessment, and even the assessment done by his own auditors, which contradicted his right to claim the amount of overall progress at 54%. Mr. Sagaya's assessment of the overall works was almost 14% less than Mr. Fideli's. Despite this, Mr. Fideli did not seek to amend his evidence or on this. My learned friend's opening statements continued to claim that 54% of the overall works have been completed. Your Honour, first and foremost, it was an explicit term of the contract that the trigger for payment, the first interim payment, was site works progress. The progress required was 30%, and such was determined by the value of the works performed on site. Submit that in this case, the defendant has not proven that it even completed 30% of the overall progress. We have not seen a single invoice or evidence of payment of the 21,800 dirhams paid to Intermetal as referenced on page 818 of the bundle. The evidence of Mr. Takei that he inspected the premises, the progress of the joinery, and found it to be non-compliant, only partially constructed, and damaged by extreme weather of Dubai, as it was sitting in an open yard. There is no evidence that supports the notion that, pursuant to industry norms mentioned by Ms. Abbas and Mr. Gaya, that the furniture was in a state that could be delivered. Furthermore, the Director of Interior 360, who provided a witness statement, has not been offered for cross-examination in this case. Chicken and egg concept has been raised as a reason why the defendant would not pay his suppliers the sums due to release the goods. Again, I submit that this doesn't fly. It's simply the case that the management of the defendant's cash flow was the defendant's concern. The defendant was the party that entered into contracts with its suppliers, and it was obligated to pay them. It was impossible for the defendant to maintain a positive cash flow with a 20% advance payment. Then it can only be assumed that the financing cost was included in the price. The defendant claims that it had expended over and above the advance payment a month before it submitted invoice 63. This also doesn't explain why the site works were not ready for delivery of goods. Progress of the works was simply not as complete as it could be, as Mr. Fadali has stated. Furthermore, Mark Takei's evidence is that the MEP was started but not complete. The fact that monies were owed to the joinery contractor and the furniture supplier, and that they would not release these items until such amounts were paid, does not explain why the contractor did not complete the MEP, lay the tiles, complete the paint works, complete the ceiling works, and have the site ready for the delivery of the final big ticket items. The defendant could have achieved 30% of site works progress without claiming the value of the furniture and joinery that was off-site. The program shows that the electrical works were supposed to have started on the 11th of November 2021, and such works were to be carried out consistently up to the 27th of November 2021. As such, this work should have been completed before the date the defendant had submitted invoice 63.
But just in terms of what should and should not have been done, there are two programs on there. So, got the program page number on that one.
247.
Yes. So we've got, no, I want to go
340.
first of all to 510 is the earlier in time, isn't it?
510. Perhaps 340 is another copy that...
Sorry?
340?
No, go to page 510. So that is...
Yes, correct. This is the original.
That's the original contract program, isn't it?
This is the one that I'm referring to in this paragraph. So you can see that the electrical, was, which is several columns down, due to start on the 11th of the 11th, 21, and then the latest is the mega test or mega test, and that was to be completed on the 27th of the 11th. The chart shows that these works are done consistently, one after the other, until the test.
Well, we've got a number. We've got a number. I mean, let's have a look at this. Flooring. So flooring was due to start on the 8th of November and be finished by the 28th of November.
Correct.
The partition work was due to start on the 11th of November and due to finish on the 21st of November.
Correct.
The electrical work was due to start on the 11th of November, but that, and so, as you say, the mega test was to be completed by the 20th. So why have we got Sunday the 12th?
I'm not sure there because the following
because we've got third fix,
yeah,
which should be the last. So no, we've got testing. Yes, mega test is the last activity, isn't it?
I think it's just listed out of order, the electrical third fix, because that seems to run consistently in the first few days.
So the last, so that's due to be done by the 27th. Ceiling. Modification of existing ceiling. So, well, the ceilings were later, and the painting and finishing were later. So it looks like floorings, partitions, MEP, and testing electrical should have been achieved by the 30th of November. Is that right? Now, the other program, we've got the 15th of December program. What's the...
$340 of the bundle.
So 15, 12, 21, 40. Look at that. So 340. Oh, sorry. So this is a program on Mr. Teke's evidence that was given to him by the defendants on the 15th of November. Is that correct? 15th of December.
I believe it's the 12th or 13th.
12th or 13th, but I'll check it in his written evidence, which wasn't cross-examined. So 12 to 13. So what does this show? This shows, so it must be as built.
That's my understanding, that prior to the 27th, prior to the date that it was provided.
Well, there's a line just at the 13th.
Correct. That I believe is.
So that must be. So it must be as built prior to that line. So in December, we've got claimed hoarding and demolition are completed. It's claimed that some of the work to the cabinets on either side of the main bar,
correct, and that's agreed.
L-shaped cabinets are done, but we've got no electrical works shown. We've got no painting works shown. Joinery. Well, that's off-site, so plaster. But no, so no floor tiling, no painting, no electrical. Okay. So I can compare the two.
The way in which they've been prepared is slightly different.
Yes, they are.
I believe the first one was prepared by Yukesh, or the team working with Yukesh at that time. He left the company shortly before the works commenced. That's not a full explanation as to why this new statement is provided, but it was the original one, is the one that was negotiated, was agreed by the parties just as the works were about to commence.
Yes.
This one was only provided to try and explain the situation as it stood at this juncture of 13th of December. And as I note between these two drawings, and as I noted in questioning of Mr. Fadali, the 10th of November is a critical date in this matter, and Takei called that meeting because he was concerned with the delays that were on site. And by the 10th of November, the demolition should have been completed under the original drawings, and we can see here on the updated as-built drawings that on the 10th of November, the demolition was still had a long way to go.
Yes.
The original program also shows that the last two stages is the joinery works on site, and this includes the furniture delivery. If joinery and furniture account for 40% of the contract, in very round numbers, the defendant could have affected the other works, the other 60% of the contract, recouped the first and second interim payments pursuant to the contract, then, over the period of the last 16 days of the project, being paid the fourth instalment, and upon completion, the final 10%. The program does not align with what Mr. Fadali has stated, that all the site works were complete, hence the works on site came to a halt. The defendant has also referred to variations and other interruptions. However, to this point, it has to be noted that no evidence has been provided of this. Extensive emails were exchanged between the parties over the course of this project. As noted, the defendant provided just 2 documents during standard production in February of 2023. The defendant has not identified a single email from the claimant that is telling the defendant to stop the works and amend the design. The defendant had an obligation under the contract to carry out a fixed and agreed scope. Any amendment to that scope was entirely at the defendant's prerogative. Instructed to amend the works, it had the opportunity to respond to the claimant by saying something to the effect of, only if you accept this change in price and allow me until X January to finish the works. Otherwise, I'll continue as contract. The defendant never did this. All of these issues are again the defendant's own making. Fadali noted the document at page 159 of the bundle was not what he would call a contract. My understanding of this was that he would normally have his customers sign a detailed set of terms and conditions perhaps a FIDIC Green Book, for instance. Such document would set out in detail the parties' rights with regards to payments, variations and delays. The fact is, Mr. Fideli, an experienced fit-out contractor, proceeded only on the basis of this letter. He never sought to use the several months of delay to rectify this issue. This document at page 159 of the bundle is the only document that captured the explicit terms of the agreement, and that document was explicit about payment being made against site works progress. Learned friend has spoken of mandatory prerequisites to termination and suggested that the parties were obligated to meet before termination. As noted by Ms. Abbas, the parties met twice in December, the second time being futile, where it was clear that the relationship had broken down. It is therefore obscure that the defendant now claims that the termination came out of the blue. In any case, this is not relevant. There is no prerequisites for the warning notice, nor a meeting. With regards to termination, I stand by the law I quoted in my opening submissions and my skeleton. With regards to damages, the court has asked for submissions on the application of liquidated damages rather than general damages. To discuss this point, I refer to the court to page 1827. Sorry, it's 1827 of the bundle.
Yep.
To the court, the delay damages would arguably apply in place of the damages relating to delay, particularly those noted in this table as rent of the site, loss of profits, and salary paid.
Yeah, I agree. That was the calculation that I gave you at the outset. The cost to complete are entirely different.
Very good. Okay. As noted by Your Honour, the delay from the 31st of December to the 23rd of March is 82 days, which is equivalent to delay damages of 410,000 dirhams. Your Honour, I firstly note that this matter has not been raised by my learned friend, and as such I have very limited time to research this matter.
Yes.
Section 89.3 of the DIFC contract law provides that termination does not affect any provision of the contract for the settlement of disputes or any other term of the contract which is to operate even after termination. Our primary position is that there is no indication in the contract that the term for liquidated damages is intended to survive termination.
Yes.
This application makes perfect sense in the event that the works are perhaps a week late, and rather than terminating or disputing the quantum, this provision would apply. However, in the event of termination, there is no fixed amount for damages. My client's interpretation of this term of the contract has so far been unchallenged by the defendant. I would submit that they agree with it. In relation to the common law on this point, I am not aware of any decision of the DIFC court that addresses the interpretation of Section 89.3 of the DIFC contract law, nor if such term has been applied to liquidated damages. Your Honour, think it prudent, I'd be more than happy to prepare and submit further submissions in writing on this point.
Thank you.
Your Honour, this concludes my submissions. Thank you very much for your time.
Thank you. It's 1 now. Mr. Mukarzal, depending on how long you want to be, we could start now, or we could come back at. If you'd like to start now, that's fine, or we could come back at 1:45.
Well, I will not be so long.
Okay. Well, if you think you'll finish, in half an hour or so, then let's go for it.
Thank you, Your Honor. Based on the trial of yesterday and the today morning one and witness hearing, evidence by the parties, it is established beyond any shadow of doubt that work has been performed by my client despite not having the exact degree of measurement by both parties. If we rely on Mrs. Abbas' statement and examination, Abbas concluded that she never visited the joinery factory of AMG and that she relied on the statement or on the photos and mark. However, this was not mentioned in the report that she submitted. We do have a big question mark on the reliability of such expertise, knowing that, according to the examination we had with Mrs. Abbas, she confirmed that part of the joinery has been accomplished, but she cannot confirm it because she don't have any authorization from the client to dispatch it. On the other side, Mrs. Abbas confirmed regarding the loose furniture of the 360, and based on her visit to the factory and the expertise, that said furniture are effectively ready sold, but for reason she doesn't disclose it, she did not confirm why such installation hasn't been authorized by the client based on the payment that should be done to the factory. Because she said also that...
Can I ask you
yes.
this question?
Yes.
Carousel. Let us assume, it's not this case, but let us assume that a contractor had purchased paint, and the paint was there in the contractor's own warehouse, but it had not been applied to the walls of the building. Would you still say that you should count the work, the painting work, as having been done?
This particular issue,
Yeah?
no.
No. So what is the difference?
Fact.
What is the difference between somebody having a piece of joinery which is not yet incorporated and paint which is not yet applied to the walls?
Honor, let's put the question in the big picture.
Okay.
This contract was made on April 2021, and the advance payment was made according to the contract on April 2021, the 20%. My client has already dispatched part of this payment to the factories to start manufacturing the furniture. What happened is from April till November, the project was stopped.
Yes.
For a reason, main reason related to the tenant. To
Not your clients, not your, not
We're
your
not
clients.
discussing this, but
Yeah.
what happened is when they resume works on November, there was at least less than 2 months to deliver the place. So my client is, I think, in a common sense and a good faith, has already speeding up the manufacturing of the furniture to match the delivery date. So I agree with you that, however, this furniture was not installed on site according to what you explained to me. This is a matter of fact, but it's clear that my client has shown total good faith and going concern all over the period in order to match the installation of this furniture. Because let's take the question on the contrary. If the client did not advance this payment to the manufacturer from the 20% and from his own pocket, because it's well known that he paid more than 75,000 dirham from his own resources. What could happen? Mrs. Abbas said, nothing will change. Of course it will change, because if the manufacturing of the furniture were not ready on December, definitely the project cannot be opened at the end of December or delivered. So this is again chicken and egg. Of course, there is a lack of workflow, but the client or the claimant should understand, and this were shown in the exchange of emails between them, between Mark at least, and Faisal and Isam, that there was an attempt to pay as a defendant an immediate payment to speed up the works. And for a reason, I don't know why, this didn't happen. So the problem is not only on the side of the defendant, but there is a major problem of cash flow on the side of the claimant. My other argument, Your Honor, is why after the termination of the 28th of January, everything went very, very lenient and very, very smoothly. Why 360 get paid on 3 POS check and the furniture were delivered and everything went well? Why couldn't this happen at the time of November when the dispute was arised by my client? So this is one argument. So the problem is not on-site or outside. However, we do insist and consider, according to our measurement and to Mr. Sagaya, that on-site have been achieved for more than 39% according to the report. Knowing that, Mrs. Abbas has liked to mention the demolition, which has been confirmed by Mr. Sagaya. I don't know to what extent this should be admitted by Mrs. Abbas to put a 2,000 dirham out of the 20,000 and to measure all the other, joinery and on-site works for zero completion, while it's obvious there is somehow a certain percentage of completion. I'm not ascertaining what Mr. Sagaya said, but it's clear that there is a work that has been done on-site the case. Second, she did not mention the hoarding works, which is 27,000. Why? This is important. This is a certain amount consistent based on the 30%. Because in my opinion, if you consider the general amount, 850,000, to 30% should be around 300 something. So any penny paid on this, if you want in the calculation, it matters for us. So, but again, okay, the interpretation could be strict to sensu and could be la to sensu. Knowing that the circumstances of this project has fundamentally changed in time of period of works and in time of delays. Knowing that my client has exerted a lot of payment to mobilize first in April, to demobilize, then to remobilize on November. That this is a payment that he made. Nobody is taking this into account on the side of the claimant. They want, why you are not at 30%? Okay, we're not at 30%, but we are ongoing concern. Even though we engaged Mr. Sagaya and his company, we paid the fees for that after the 28th, after the stop of work, in order to make sure that we are aligned with the terms of the contract. So this is important to mention, Your Honor. Secondly, it is clear that alongside it is also, despite the contract being silent on the remedy of any defects or default from the parties could have attempted to resolve the dispute amicably to accomplish the work in hand, knowing that there was it's a small project relatively between the parties, and there was a certain relationship between the two parties, definitely between Mr. Al-Mandil and Mr. Fadali.
But Ms. Abbas says that second meeting broke down with finger waving at each other.
Yes. So this is, I think this is a proof that the problem is not a question of payment or no, it's a question of ego, maybe. But I'm not entitled to entertain on this matter. Anyway, for me, this project could have been solved easily by dispatching a certain sum of money. Your Honor, you are a specialist, not only on the law side, but as I understood, you are a specialist on the contracting side. My client have made everything ready to install the furniture. If my client wasn't going concern on this project, and he's not involved, why he should press on the grease factory to dispatch and to ship the furniture to Dubai in order to be ready for installation at his own responsibility? Why he should press on AMG joinery factory to make everything tailored and ready, just need to be painting, because when payment will come, it will definitely be installed. So this is part of the on-site somehow, not only on-site, on the whole contract, on the achievement of the project on time. Suppose this furniture were not ready. We got the works on site, 30%, 40%, 100%. If the furniture are not ready, are we ready to open on December 30th? No. This is what I'm against what Mrs. Abbas said, that if we pay, the problem will remain the same. No, because 30% on site is nothing. It's a question of works, it's a question of workers, question of sealing, demolishing. So this can be done. It's not a big deal. The big deal is the decor, is the furnishings, the lighting, the installation. This is what makes a restaurant opening.
If what was on site was nothing and could be dealt with easily, why wasn't it?
Why wasn't it? Because
yes.
You want the reason, as I understood from the client,
yes.
Finally, because we were not fixed on the reliability of the claimant to continue pay us. We were thinking that we are trapped to do the work and then go out and go claim your money. This was the impression we had because of this kind of meetings between the two parties where ego was playing a lot of...
But this is later. We have to go back to the 17th of November.
Yes.
I mean, what you're telling me just a moment ago is that as at the 17th of November, it could have easily have finished all of the work on site. So why did they stop work on site? Now, I've heard evidence from your client that he was very busy at the time because he'd had to reschedule the work. He had work on other sites. He lost his site manager who went back to India. What it sounds like to me is that he had problems with his manpower in the middle of November, which was why he stopped work.
Could be, because he said it. Could be, that's true, he said that, but
well,
it doesn't mean that if he get paid on time, he couldn't put the works on an intensive course and finish the job properly. Knowing that...
but by the 17th of November, he wasn't asking for payment. But that's when he stopped.
Wasn't asking formally. He wasn't asked formally, but there was a lot of discussion orally between him and Mr. Mandi.
There's no evidence. I mean,
there's no evidence because when you ask him, he said this is orally. I know there is no evidence. That's why on end of November, the invoice was issued.
Yeah, but they didn't put so why didn't they put an invoice in the middle of November then?
Maybe because they didn't reach the 30% maybe at the middle of November. I don't know.
No, but that's the whole...
I have no clue.
But that's the whole point. That if they hadn't reached 30% by the middle of November, then they stopped work in the middle of November. And you say maybe they stopped work when they hadn't actually reached 30%. This is the problem.
I'm not sure they stopped work on the project. Maybe they stopped work on the on-site because there is some works to be done. But he continued to chase the factory, he continued to chase the warehouse. Maybe he has some reduction on the staff, but he never gave up. That's the understanding I had from his statement and the statement of the other defendant witness. And other things that I cannot explain is why the joinery works that have been made by AMG that we couldn't, unfortunately, question the witness today, in the morning. Mr. Malik al-Khatib, he said in his statement, and maybe we can review it, that a visit have been made by Mark to the factory, and Mark, he expressed a good satisfaction on the works done. And we were waiting from Mark to give the latest design sketch and the go in order to deliver and continue the manufacturing.
Well, this evidence wasn't challenged.
That's been challenged, but I had to stress on it that.
Well, you're entitled to. You're entitled to say, look at his witness statement.
Yes.
It wasn't challenged in cross-examination. You should accept what he says.
Yeah.
Yeah.
Exactly. Then, so for us, for my client, it's clear that 30% of the project on site was accomplished as per the auditor, Mr. Sakaya, appointed by the respondent, has stated. And I do agree with him because we made it clear, he made it clear on his statement that the 39% he referred to on his statement is related to the on-site work. And he included, I agree, the loose furniture. But again, Your Honor, the loose furniture could be next door and could be at factory. But in both cases, they are ready to install. So whether you consider it on-site or off-site, this is the debate. For us, it's ready to install. And Mrs. Abbas confirmed it. If we get the payment, this furniture will be on-site immediately. That's why she didn't mention it as on-site. But for us, it's ready to do. And part of the contract, this will be essential to meet the date of the delivery date of December 30th. Because without furniture, how can you open a restaurant? So, the witness statement of Mr. Sharif also was clear that on-site and off-site was performed to deliver the project. So Sharif and Mr. Fadali made it clear that at the time where the works resumed, which is November, and he made it clear that he was he asked from Mr. Mandil to start the work on 17th of November, but because Mr. Mandil insisted to start on 1st of November, he agreed. So that's why I gave a certain explanation to your queries, Your Honor. That's why there was not a lot of people on site, because my client has to demobilize other projects and bring new staff again on the site, because this site was stopped from April to November. And from April to November, I don't think any contractor can wait without having any other job. So, having said that, it was clear that the project was accomplished from our client without having any free or cash flow, which is essential and which was the reason of the assistance of my client to have the second payment and the interim payment, the first interim payment released on time. So this is the chicken and egg situation, Your Honor, that led the parties to such dispute. The lack in the flow and the cash flow and the work, and eventually and essentially and definitely, the unilateral and abruptly termination of this contract without at least attempt to state it or to have a remedy or to check why project should be stopped like that, and why we need to have another contractor. In my opinion, and in the opinion of my client, and what it appears, statements of both parties, this could be easily solved. This could be easily solved if Mr. Mark, in his statement and exam, he said that we're reaching 15 to 20% on site, while he written 10%. I mean, it's a fistful of dollars. With a fistful of dollars, this project can be maybe delivered before December, because everything was ready. We just need to fix the lights. We just need to make some cladding and some internal works, and that's it. Now, insisting on what is on site and off site, in my opinion, it's not the main issue, knowing that what has done on all projects was ready to be delivered on time. So saying that my client didn't show any interest in doing this project is not true, because till the end of January, till he received the termination letter, we were working and assessing the project in order to and one argument, and I will finish here. Why Mrs. Abbas, and she said yesterday, she was not authorized to discuss her report with the client. She was not authorized, knowing that she was not only acting as an expert, she was acting as a GM, and she was the one to issue the termination letter. I'm wondering if, when she was appointed, there was not in the mind of the claimant a decision to kick out my client from that day. Because if we could have discussed this report, maybe my client should have readdressed some issues, or maybe she has concluded to some conciliation with the claimant and solved the project in a proper way and on time still. So for all this reason, I'm not seeing any legal ground from my colleague and from the claimant to ask for any compensation for any delay or for any defaulting that my client is accused of. On the contrary, my client has all rights to claim and counterclaim the damage he has suffered from not being allowed the project till the end, and from all the stress and the cost he incurred of the delays starting from the side of the claimant and from the non-payment of a lawful second or interim.
Thank you. Do you have anything to say about the claimant's damages claim, the calculation at all?
I mean, it's too technical for me. As a calculation, I'm not seeing a big difference. What I'm challenging is the principle in itself.
You challenge the principle, yes. Okay, well, thank you very much for your economical and attractive submissions. Good. Okay, and it's just 1 o'clock. So thank you both very much indeed. I will reserve my judgment and I will carefully reread all of the witness evidence again and the calculations. I'm afraid next week I have to go to a construction law conference in America, so it'll be a couple of weeks before.
We're more enlightened now.
It'll be a couple of weeks before I'll be able to produce a judgment, but thank you very much indeed.
Thank you, Your Honor.